Straight ahead on Law&Crime Daily, the deadly Uvalde school shooting.
We trained our kids to sit under the table, and that's what I thought of, at the time, but we set them up to be like ducks.
Hear from a teacher who survived the attack. And
that's why Johnny Depp lost in UK, and that's why he won the trial here.
The differences in the Johnny Depp's United States and United Kingdom trials. Plus,
we're going to make the media pay for what they did to me.
Kyle Rittenhouse files suit for alleged media defamation. And later, things get heated in Broward County.
I don't intend to have any contempt hearings, but I believe your refusal to participate would be a clear violation of Florida law and the rules of professional responsibility.
The latest in jury selection proceedings for the Parkland school shooter. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmeyer. For the very first time, we're hearing from a Robb Elementary School teacher and survivor of last month's deadly shooting in Uvalde, Texas. 19 students and 2 teachers were shot and killed on May 24th when an 18-year-old gunman opened fire in the school. 17 others were injured. The gunman used an AR-15 style rifle to shoot and injure his grandmother before making his way to the school. He entered through an unlocked side door and remained inside for more than an hour as multiple students inside the building called 911. He was later shot and killed by Border Patrol agents. 4th grade teacher Arnulfo Reyes says he remembered his emergency training and told students to crawl under their desks and pretend to be asleep. When the gunman entered his classroom, all 11 students inside were shot and killed. The 17-year teaching veteran was shot twice and struck in the arm, lung, and back. Speaking exclusively to Good Morning America, Reyes says it took 1 hour and 17 minutes from the time the gunman entered the school for officers to enter the school. At that time, multiple 911 calls were made from inside the school, and several students inside called out to police. For that, Reyes says he can never forgive emergency responders.
Did you feel abandoned in that moment by police, by the people who are supposed to protect you?
Absolutely. After everything, I get more angry because you have a bulletproof vest. I had nothing. I had nothing. You're supposed to protect and serve. There is no excuse for their actions. And I will never forgive them. I will never forgive them.
In the wake of this shooting, families of 4 students injured in the shooting have filed a suit against the gunman's estate. All students involved in the lawsuit are either 9 or 10 years old. In a statement, the students' attorneys said the discovery process will focus on the school system, law enforcement, social media, as well as gun and manufacturing ammunition companies. That means the attorneys' team will focus on law enforcement's response to the shooting, how the gunman entered the school, and how he obtained the weapons and ammunition. The team of attorneys will also investigate whether there were any red flags of violence or threats that were not reported to emergency officials. Joining us today is co-host Terry Austin and civil rights attorney Joe Richardson. Joe, if officers outside the school ignored cries for help and multiple 911 calls, do they not have a legal duty to act, and could they face criminal charges?
Well, it'll be interesting to see what happens on the criminal side, but I would say that it's not as easy as it sounds. It's certainly morally wrong. You certainly could accuse them of miscommunication at best, or Neolithic incompetence at least. But when it comes down to it, there's actually no duty to protect someone that's not in your custody. So the police may not actually have a legal duty because they're not in custody, as crazy as that might sound. And going over to the civil side, we'll see what happens there as well for the same reason. We don't know that there's a legal duty that makes it legally actionable on the civil side. On the criminal side, I think it's a tough road to hoe to bring cases against the police for the same reason.
Yeah. Now, Terry, this is more of a broader conversation, I guess. Is focusing on police response part of the discussion of gun violence in America, or is it a separate one, and should we be focusing on preventing a mass shooting like this from happening again?
Brian, we should be focusing from all perspectives. We should have preventive measures like making sure we look at mental health issues. We should have proactive measures like making sure we limit gun access. We can do that by raising age limits. I've said this before, increasing the waiting periods, thorough background checks, and more importantly, banning assault weapons, bump stocks, and high-capacity magazines. But we can also look at post-event measures like making sure the children know what to do, making sure the police know what to do. But that is a last resort. We have to look at this holistically.
Absolutely. Well, following the Uvalde mass shooting and several others across the country, New York raises the age requirement to purchase a semi-automatic weapon in the state. On Monday, Governor Kathy Hochul signed the bill into law, now prohibiting any New Yorker under the age of 21 from purchasing a semi-automatic weapon. On top of that, anyone who purchases a semi-automatic rifle will be required to get a license, something previously required only for handgun owners. This makes New York the first state to enact a major gun control initiative following the string of deadly shootings. In all, Hochul signed 10 public safety bills, among them one that would require microstamping on new firearms in an effort to help solve gun-related crimes. Another would revise New York's so-called red flag law, allowing courts to temporarily take guns away from people who could be a risk to themselves or others. Still ahead on Law and Crime Daily, less than a year after his acquittal, Rittenhouse files suit against top social media giants. But first, comparing Johnny Depp's lawsuits, why the Pirates of the Caribbean actor lost his UK suit but came out on top in the United States. Welcome back. An update now on a story we first brought you here on Law and Crime Daily. Johnny Depp files an opposition at the ACLU, pushing back on a requested $86,000 reimbursement payout. In court documents filed back in April, the American Civil Liberties Union, better known as the ACLU, requested more than $80,000 in reimbursement for the organization's involvement in the defamation case. The lawsuit claims the organization complied with a subpoena, revealing nearly 8,000 documents. In court documents filed last week, Depp's team claims the ACLU is not entitled to attorney fees. The filing says reimbursement should be limited to less than $2,000, only for costs associated with providing ACLU documents. The ACLU played a significant role in the defamation suit, as Heard pledged part of her divorce settlement from Depp to the organization. Members of the organization also helped Heard draft the Washington Post op-ed that would become the basis for Depp's defamation claims. In the days following the monumental verdict in Depp's defamation case against ex-wife Amber Heard, we're hearing from top legal analysts, some who say critics should stop comparing the recent United States verdict with Depp's previous trial in the UK. Back in 2020, a court in the United Kingdom ruled against Depp, who sued The Sun, a British tabloid, after an article referred to him as a wife-beater. 2 years later, an American court ruled in favor of Depp, who claimed he was defamed by Heard in a Washington Post op-ed. But experts explain there were many differences in the two trials. For example, a single judge ruled against Depp in the United Kingdom, whereas a jury of 7 ruled in favor of him in the United States. But experts say the most important difference is that Amber Heard was not a party in the United Kingdom trial.
If you're not a party to the case in the UK trial, you are not obligated to disclose certain information to the court. Johnny Depp's legal team requested the judge for what they called a third-party disclosure, which is asking Amber Heard as a non-party to disclose certain information that they need for the trial. The judge in UK denied that request by Johnny Depp's legal team. But at the end of the day, the UK judge does not have all of the evidence that was presented in the US trial, because here, Amber Heard is a party to the case, which means that Amber Heard is legally obligated to disclose or produce information as a party to the case. That was not the case in the UK trial. So as you can imagine, the evidence on both trials are different. That's why Johnny Depp lost in UK, and that's why he won the trial here.
All right, Terry, what do you make of Johnny Depp's countersuit against the ACLU? And does it matter or help the fact that he won his case against Amber Heard?
I don't think that really makes the difference, but I think they filed that countersuit to just legally protect Johnny Depp. I mean, those claims that the ACLU are trying to make are exorbitant. They are excessive, and it's not supported by New York law. New York law provides that reimbursement should be for reasonable expenses, not for attorney's fees. Maybe the ACLU wanted to protect themselves. They wanted the lawyers to look over the documents, and there were some 7,500 documents that were reviewed. They produced 2,000 of those documents. They had 3 witnesses, and all in all, they can be reimbursed, but I think at the end of the day, they're going to come to some sort of settlement at a reasonable amount, not at the amount that the ACLU is requesting.
Yeah. Now, Joe, do you think the differences in these two cases, the UK and the US, comes down to 2 different judicial systems and causing a different outcome in the trials, or were they just 2 different cases altogether?
There were 2 different cases. There were 2 different legal systems, different standards. Also, to the point that was made earlier, Amber Heard's villainous nature did not exactly come through because she was not a party in the other case. But at the end of the day, this was about having a judge versus having a jury. You just have a different presentation when you go to the judge. There are several things that the attorneys for Johnny Depp could do in front of the jury that would have an effect. The cross-examinations, as brilliant as they were by Camille Vasquez, would not have moved a judge. They wouldn't have been done in front of a judge. You have a completely different strategy when you're trying a case in front of a jury versus a judge, and I think that's the biggest difference.
All right, we'll see what he does with the ACLU case as well. Thank you both. Coming up on Law and Crime Daily, in a renewed push after the Johnny Depp trial, acquitted Kyle Rittenhouse sets his sights on defamation lawsuits of his own. Plus, contention in the courtroom as jury selection in the Florida death penalty trial for an accused shooter continues. Welcome back. Fresh off the heels of the Johnny Depp Amber Heard defamation trial, Kyle Rittenhouse says he feels it's now time to push ahead with his own defamation lawsuit. Rittenhouse was acquitted last year of murder after he fatally shot 2 men and injured another in Kenosha, Wisconsin in 2020. The shooting happened during riots and civil unrest following the shooting of black man Jacob Blake by a white police officer. Rittenhouse, who was 17 at the time, says he traveled across the state line from Illinois to help protect a friend's private property and help as a medic in case it was needed. Protests turned violent and destructive. That's when Rittenhouse killed 2 and injured a 3rd man. Rittenhouse now says several media outlets and social media personalities defamed him, calling him a murderer or white supremacist, making everyday life difficult.
We're going to make the media pay for what they did to me. They made it hard for me to live a normal life. I can't go out into public. I can't go to the store. It's hard for me to go anywhere without security. Shoot, doing basic things like taking my dog to the dog park is difficult. So they made it really difficult to be normal.
Kyle was charged with a crime. News organizations are allowed to report on that. But you know, calling somebody a murderer in certain circumstances can be actionable. Other things that media personalities, people on social media said were clearly defamatory.
Terry, do you think Johnny Depp's recent win against Amber Heard motivated this lawsuit? And do you think the fact that Depp won could help Rittenhouse do the same?
You know, I'm not sure what motivated the Rittenhouse lawsuit. Maybe he felt empowered. But frankly, I don't see his claim prevailing. I think the 2 cases are completely different. The Depp-Heard suit was 2 different cases where you had defamatory statements made against 2 individuals. The Rittenhouse case is totally different. He has killed 2 people, injured a 3rd. It was a murder trial, and essentially the press is allowed to absolutely report on that. Now, yes, you're innocent until you're proven guilty. But the fact that he's got people looking at him differently and people are talking on social media, if the press acted responsibly and talked about the case, I don't think there's going to be a defamation claim against. I mean, obviously, you have to say that it's false and that it caused injury. So I'm not sure he's going to be able to prove all that.
Yeah, and Joe, that kind of leads me to my question for you. How strong does Rittenhouse's case look to you? And would Rittenhouse be considered a public figure like Johnny Depp was?
I think there's an argument that because of what was happening with him at that time, he would be a limited purpose public figure. That's not good news for him because that means there's a malice standard. So in other words, there has to be knowing falsity, reckless disregard for truth, and it is a higher standard. And so it is difficult to show that he has actually been defamed. And even the attorney himself says in certain circumstances, you can't call him a murderer. Therein lies the rub. There's an argument that you can call him a murderer because he did murder, he did kill. That does not mean he was convicted legally. He's not a convicted murderer. He was not convicted of murder, but he did kill those two people. He's not like somebody else like an O.J. Simpson who claimed it didn't happen. People wanted to believe it, but they never had it proven. No, he actually pulled the trigger even though he got off. And so therefore, I think he's going to have a real difficult time proving defamation here.
I would agree there, especially when you consider what self-defense actually means. Well, thanks for that breakdown. When we come back, jury selection in a Florida trial has dragged along, but is once again moving forward after several motions from the defense team in the death penalty case of the Parkland school shooter. Welcome back to Law&Crime Daily. Jury selection in the death penalty trial for Florida school shooter may be moving forward, but at a snail's pace. And on Monday, the 23-year-old's public defenders tried to withdraw from the case and have the judge removed. The shooter took responsibility for the February 2018 Marjorie Stoneman Douglas High School shooting last October, pleading guilty to 17 counts of murder and 17 counts of attempted murder. Despite the guilty plea, prosecutors still intend to seek the death penalty. The jury selection process has been plagued with setback after setback, the latest being a shooting at an elementary school in Texas. The gunman's defense filed a motion to delay his trial indefinitely, saying the Texas shooting reawakened emotions, arguing it makes it impossible for their client to have a fair trial. While the judge did not rule on that motion, she did rule on two others. Defense attorneys asked the judge to disqualify herself from the case, but she denied the motion. And the judge ordered jury selection to continue even though a second member of the defense team, who was brought in as a death penalty expert and specialist, is out sick with COVID-19. It became the scene of a tense standoff Monday, pitting the defense against the judge, who had grown openly tired of the delays.
I don't intend to have any contempt hearings, but I believe your refusal to participate would be a clear violation of Florida law and the rules of professional responsibility. Are there separate rules of professional responsibility for a capital case? Because this cites the rules of professional responsibility.
And that is when the counsel was ordered by the court to go forward. I haven't heard the court order me to go forward. Are you ordering me to go forward?
I am saying that the trial is going forward for you and that the jury selection is going forward. For you to then say that you're going to intentionally create ineffective assistance of counsel is in clear violation of the Rubin case and your rules of professional responsibility.
And if Judge, at this time, the defense would move to withdraw from the case of State of Florida versus Nikolas Cruz. Right now, if I do not comply with the court's order and do not protect Mr. Cruz's constitutional rights to due process, I now have to consider whether or not my liberty is going to be in jeopardy or Mr. Cruz's liberty is going to be in jeopardy. I'm also going to have to consider whether or not my law license can be impacted, which would impact my ability to raise my children, feed my children, and educate my children. So if you're ordering me to do that, and I fail to do that, I'm at risk of being held in contempt because I'm in a battle right now between my liberty and my client's liberty.
All right, respectfully, your motion to withdraw is denied.
For 2 months, prosecutors and attorneys have been trying to pick 12 jurors and 8 alternates for the upcoming months-long trial, which will decide whether the Parkland school shooter is sentenced to death or life in prison. Joe, how do you think the judge will rule on the delay based on the Uvalde school shooting?
I could see perhaps there being some delay related to the sickness of the second attorney, who's a specialist, but not because they believe that the Texas shooting has evoked emotions. Frankly, you could be that reflective every day of your life right now. And who's to say sometimes within the next 4 months, when this is supposed to be going on, there's not going to be another such instance. You have a right to a speedy trial, and most of the time, the judge lends toward things getting to their resolution. So they're less likely to grant a motion to continue anyway, let alone for an arbitrary reason about what's happening in Texas, because they feel like people will be emotional about it. You can never judge when that's going to end, and therefore the judges would have to make a choice and would not end up continuing. I seriously doubt it.
I agree as well. Terry, is there some strategy or reason for delays like this, or is this just such a big case making it so difficult to pick a jury?
Listen, it may be a strategy, but I think the defense is grandstanding. I really like this judge. I think she's making the right decisions. Look, everybody wants the defense to be perfect. You want to have that attorney in there defending this client, making sure you have a death penalty attorney. Consequently, you want to, make time to have him come back from being sick from COVID. But at the same time, you need to have this trial go forward. It's been going on for months. Jury selection has to be concluded, and the judge has to make the decision how she's going to run her courtroom. So I think there's a little bit of grandstanding here, and I do think it's a difficult case, but the judge is making the right decisions.
All right, we'll see when the first juror is selected. Thank you both, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.